Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
A video clip of then-attorney Lorenzo Larry Gadon lashing out and uttering profanities against journalist Raissa Robles surfaced online and went viral on various social media platforms. The Supreme Court had motu proprio issued a resolution on January 4, 2022, taking cognizance of the subject video clip of Gadon and ordered his preventive suspension from the practice of law effective immediately. Gadon was also ordered to show cause why he should not be meted with the ultimate penalty of disbarment in connection with his viral video. The court noted that this was not the first time that Gadon has displayed similar behavior in public and noted other similar incidents. On June 27, 2023, the court on Banc, by a unanimous vote of 15-0, resolved to disbar Gadon and found him guilty of violating the Code of Professional Responsibility and Accountability and direct contempt of the court. His name was also ordered removed from the roll of attorneys. The practice of the law is a privilege, not a right. Under what circumstances can the ultimate penalty of disbarment be imposed against lawyers? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 4th of April 2025, and today we talk about when the ultimate penalty of disbarment is imposed against a member of the bar within the context of the Supreme Court en banc decision in the case of In Re Attorney Lorenzo G. Gadon's viral video against Raissa Robles, AC number 13521. The per curiam decision was promulgated on June 27, 2023. And joining us to talk about this case is Attorney Paolo J. Santiago, member of the Philippine Judicial Academy's Department of Humanitarian Law and Human Rights. Hi, Attorney RP. Thanks for joining us and welcome to the Supreme Court Podcast.
Hi, Attorney Mike. Happy to be here and hello to everyone who's listening to this podcast.
For context, Attorney RP, what exactly was the content of the viral video of Mr. Gadon?
Okay, Attorney Mike, the video was about an impassionate plea or reaction of Mr. Gadon against a certain journalist, Ms. Raissa Robles, and he used words in his recording such as "puki ng ina mo, hindot ka, putang ina mo," and then he also used threatening words like magpakantot ka sa aso and repeated those expletives. So again, his impassioned broadcast contained words that were both expletives and at the same time they were obscene.
In requiring Gadon to show cause or explain why he should not be disbarred, the Supreme Court initially found that his language in the subject video recording against the journalist Raissa Robles was violative of the Code of Professional Responsibility and could constitute gender-based online sexual harassment under the Safe Spaces Act. How so? What do these provisions say?
Republic Act number 11313 is our Safe Spaces Act, or it's also known as the Bawal Bastos Law. And in this case of Mr. Gadon, the video that we're talking about was actually put on social media and it became viral. So because of what he said there, it was found to have violated the provision on gender-based online sexual harassment. Gender-based online sexual harassment is an online conduct that targets a particular person that which would cause or likely to cause mental, emotional, or psychological distress and fear of personal safety issues. It can be done through threats. So in this case, there were threatening messages and at the same time expletives, obscenity that were hurled by Mr. Larry Gadon against Raissa Robles, who is a female journalist. So according to the law, these acts which are uploaded in an online platform can actually violate the law whether it is done publicly or through direct and private messages. And this is important to mention because one of the defenses of Mr. Gadon was that, this was not supposed to be posted on social media. This is really
Right.
a direct message to Miss
To
Raissa
her.
Robles. Yes.
So the Supreme Court found it fit to require Gadon to explain why he shouldn't be disbarred. It's important to point out that in this case, it's the Supreme Court itself that initiated the administrative case against Mr. Gadon. In what instances and under what authority can the Supreme Court on its own initiate an administrative case against a lawyer?
In this case, maybe it's worth mentioning that the power of the Supreme Court is based on the Constitution because the Supreme Court has been mandated by the Constitution to promulgate rules, particularly on the practice of law. So that's why it's an inherent power of the Supreme Court to discipline lawyers. Now, when we're talking of the legal profession, all lawyers are considered as officers of the court. And part of our duty and responsibility as an officer of the court is to ensure that, the legal proceedings, the perception of lawyers and the law are well respected and dignified. So if there is any unfitness that is seen by the Supreme Court, especially if it's such of a gravity that is already alarming, the Supreme Court does not need to wait until someone files a complaint. The Supreme Court can act motu proprio, and this is again based on the rules itself that had been promulgated by the Supreme Court.
Walk us through the process, Attorney RP, of how a disbarment case can be initiated and what happens. For example, as we mentioned, it's either the Supreme Court on its own can initiate it or somebody can file a complaint against a lawyer. Then what happens next?
That's right. So if a complaint is filed or if there's a motu proprio complaint that is recognized by the Supreme Court, usually the Supreme Court has the power to ask either the Office of the Bar Confidant or the Integrated Bar of the Philippines to conduct an investigation. This investigation is really to get into the meat of the matters, to find out what's happening, to allow the respondent to be able to submit his or her defenses against the allegations against him or her. And then based on that, if it's with the Integrated Bar of the Philippines, usually there is a committee on bar discipline. No? There would be a formal disciplinary hearing that will happen. So after the disciplinary hearing, the Integrated Bar of the Philippines would give its recommendation to the Supreme Court. Only a recommendation because the Integrated Bar of the Philippines does not have the power to discipline lawyers. So this recommendation goes to the Supreme Court. The Supreme Court checks everything that happened, looks at the conduct of the investigation, what were the defenses, what were the allegations, what are the recommendations of the Integrated Bar of the Philippines, and then decides on its own as to the kind of sanction that it will give to the lawyer.
Well, this determination is ongoing, Attorney RP. Can lawyers be put on preventive suspension? Because this is one of the objections of Gadon, right? He said that he hasn't even received a copy of the Supreme Court resolution, which required him to show cause why he should not be disbarred, and he hasn't even answered that allegation or that show cause. So why was he put on preventive suspension?
Yes, and this is actually very interesting. It's very interesting because usually, the usual cases that are administrative cases that are being investigated by the Integrated Bar of the Philippines, usually they are not suspended yet or preventively suspended. But in this case, Mr. Larry Gadon was immediately put on preventive suspension as a lawyer. And when he questioned it, the Supreme Court pointed out that disbarment cases are sui generis. Now, sui generis is a term that we use to say that it's a class on its own, meaning that it is not a civil case, it is not a criminal case, it's an administrative case, but the issue is to determine whether or not the person, the lawyer, is still fit to continue to be an officer of the court in the dispensation of justice. But as pointed out by the Supreme Court, this preventive suspension is different from a preventive suspension that is given to an employment status. No? In this case, we have to remember that the practice of law is a privilege. Now, we are not, we as lawyers do not have a right to insist that we have the right to practice law if we are deemed to be unfit. So in this case, the Supreme Court found damning evidence immediately, no, to preventively suspend Mr. Larry Gadon. And then I point out again, no, this is a sui generis case. No? So it's the Supreme Court that has the discretion based on its constitutional power to discipline lawyers. And yet this is not yet disciplining Mr. Larry Gadon. The only reason why the Supreme Court did this is in order to protect the legal profession and the judiciary as well. No? Because imagine the video that was uploaded is already so scandalous and downright offensive, as mentioned by the Supreme Court. In fact, the Supreme Court also used another Latin term in its decision. It used res ipsa loquitur. If you see the video itself, the thing itself speaks for itself how scandalous and offensive it is. And the Supreme Court pointed out Mr. Gadon does not deny that he actually created the video. There was no doubt as to the authorship of the video. He was just claiming, well, that was not supposed to go viral. That was supposed to be a private message to Raissa Robles. But yet, since it went viral and there is no dispute as to the authorship, no, the Supreme Court had to protect the legal profession and had to do something, because otherwise, if it takes it sitting down, the Supreme Court might be accused of actually allowing such a scandalous action to proliferate and not do anything against lawyers.
And before we go to the substance of the ruling, Attorney RP, I just want to ask about a point raised by Mr. Gadon on inhibition, because because in his response, he did say two of the justices of the Supreme Court, and those are Senior Associate Justice Marvic Leonen and Associate Justice Alfredo Benjamin Caguiwa, should inhibit. He has his own reasons, but these reasons were not meritorious by the court. So when can there be a valid ground for inhibition of a magistrate? Are there cases where the inhibition is mandatory?
Yes, according to the rules of court, Rule 137 of the rules of court, there is what we call a mandatory disqualification and a voluntary inhibition. A judge is mandatorily disqualified if he or she has a personal interest or bias in the case. For example, if the judge has a pecuniary or financial interest, or the judge served as a lawyer in that case, or there is someone who is related to the judge within that particular case, then the judge has a personal interest. Or if there is a previous legal involvement, again, the judge was a previous lawyer or part of a firm that actually handled the case, then that's a valid reason for the judge to mandatorily inhibit himself or herself. There is also this ground called voluntary inhibition. In voluntary inhibition, if there are doubts against the impartiality of the judge, or if based on the public perception, there might not be confidence in how the judge will handle case, such that it might erode public confidence in the judiciary, a party may actually request that a judge voluntarily inhibit. But it has to be pointed out that inhibition is not used as a strategy, as a legal strategy, and mere allegation of bias is insufficient. It has to be pointed out, why is it that this particular judge or justice has to inhibit? It's not as if just because in this case of Mr. Gadon, he said that he actually criticized these two justices. But even if he criticized them, there must still be evidence presented, or at least some proof that is presented, that these justices or a judge actually is acting against the interest of a person. But if it's mere allegation of a speculative bias, again, it is not a legal ground to seek for inhibition of a justice or a judge.
And one interesting aspect of this case is Gadon was initially charged of violating the Code of Professional Responsibility. But in the course of the proceedings, the CIPRA, or the Code of Professional Responsibility and Accountability, was actually passed and approved by the Supreme Court, and it applied the particular provisions of the CIPRA to Mr. Gadon. So, what exactly is the violation of Mr. Gadon under CIPRA?
According to the Supreme Court decision, Mr. Gadon violated three sections were actually four sections were identified. Three pertain to his conduct, and the last pertain to the use of social media. These particularly are sections 2, 3, 4, and 36 of Canon 2 on propriety of the CIPRA. So section 2 talks about the dignified conduct of a lawyer. So I won't read through it or explain it, but from the title itself, we have to conduct ourselves in a dignified way. The second is safe environment and avoiding all forms of abuse or harassment. So in short, we as lawyers have the duty to ensure that we provide a safe environment for everyone. So we should not be the ones who would lead an abuse or cause a harassing environment against anyone, whether it is in the workplace, in public setting, in educational or training institutions. We must not be the harbingers of these kinds of toxic environment. Section 4 is about the use of dignified, gender fair, and child and culturally sensitive language. As lawyers, that's why we have been educated in the law. When we talk of principles such as equality, non-discrimination, we should always be sensitive as to how we use our language tool, because words can hurt and words can oppress and words can create inequality and discriminate others. So that's why that section 4 mandates us to use dignified, gender fair, child and culturally sensitive language. And the last is the responsible use of social media. Because at this day and age, we do know that social media is a platform. Everything that we say, that we do, can actually find its way in social media. So even if we are not the one using it, we have to be aware that whatever we do can actually be used and posted on social media. And remember that it is not just us, the lawyers, who are affected. It is the perception of the public on justice dispensation. We, as officers of the court, are responsible to make sure that we help our justice actors, for the public to have faith in the justice system.
And one question here is, wouldn't it be unfair on his part that the new rules have already been applied to his conduct?
Well, as lawyers, the Supreme Court, regardless of whether it's the CIPRA right now or the CPR before, the Code of Professional Responsibility, no, has always been consistent that we, our lawyers, are held to a higher ethical standard. That's part of being in a legal profession. No? We have this code that we have to adhere to.
It's interesting that you mentioned social media, because this is the first time that the code actually has explicit provisions regulating social media. But can the defense of Mr. Gadon be raised that he was doing it in his private capacity? He didn't want, or he didn't intend it to be live streamed or shown or shared across social media. And one other defense that he had is that he was doing it in his private capacity, not as a lawyer, perhaps. So, is he's trying to invoke a dichotomy between your personal life and your life as a lawyer?
The Supreme Court pointed out, even if you say it's in your own private capacity, your anger or your passion is not a legal excuse, because
Mm-hmm.
how you express yourself is a reflection actually of not only of yourself, but the public sees you as someone who should be helping in the dispensation of justice. So if you are part of the injustice from that perception of the public, then you are creating a problem in terms of trusting the legal system.
Mm-hmm.
Okay. And then lastly, we cannot, the court pointed out, since we have a higher legal ethical standard compared to someone who's a non-lawyer, we cannot
Mm-hmm.
tell other people, like when you're playing games, you will say, time out first. No, I'm not a lawyer now. No, the Supreme Court pointed out, you'll always be a lawyer, whether
Mm-hmm.
if your conduct is seen publicly outside or whether you are doing things privately. You will
Mm-hmm.
always be a lawyer, and you would have to comply with the exacting standards of being a lawyer.
Mm-hmm. Mm-hmm. Attorney RP, the penalty of disbarment has been referred to as the supreme penalty for lawyers because, like, you're ending your chance to practice a profession which you studied for so long, which you practiced and hope to practice until probably until the end of your career. So, when can that penalty be meted out? Uh, if, say, Gadon had done this only once, would it have merited disbarment? Or does it come if you've already done this repeatedly, multiple occasions?
Okay, so as you mentioned, disbarment is the ultimate penalty that
Mm-hmm.
can be given. So it's really given for very severe cases. And in the case of Mr. Gadon, what sealed it is it's not his first time that he has already
Mm-hmm.
been sanctioned by the Supreme Court. He had been suspended by the court in the past, and the court already warned him.
Mm-hmm.
And then what the court also looked into are whether there are pending administrative cases against Mr. Gadon before the Office of the Bar Confidant and the Integrated Bar of the Philippines. And there were
Mm-hmm.
numerous cases pending. Again, one can argue that these are still pending cases. That's right. But
Mm-hmm.
the fact that he has already been suspended in the past, warned about a higher penalty if, again, an administrative case is filed against him,
Mm-hmm.
depending on the gravity. And as we've been discussing here, the expletives and the obscenity is a very high, it's a grave offense. Grave
Mm-hmm.
offense against the Safe Spaces Act. It's a grave offense against the Code of Professional Responsibility and Accountability. And the fact that so many other people filed administrative cases against him, the Supreme Court just concluded that it shows the character of this person who is
Mm-hmm.
unfit to become or to continue as a lawyer. We have to emphasize that the fitness of a lawyer is a continuing requirement of the Supreme Court. No?
Mm-hmm.
Just because you passed the bar, took the oath, you were of good moral character when you became a lawyer, it doesn't mean that you lose your good moral character while you're a lawyer. No? So the Supreme Court emphasized this is a continuing requirement.
Mm-hmm. And Attorney RP, in a disbarment case, can you cite mitigating or aggravating circumstances, almost similar to a criminal case?
The Supreme Court can look into it.
Mm-hmm.
Of course, any defense of a lawyer who's facing a disbarment proceeding, this lawyer would rarely would the lawyer say that yes, I committed an
Yeah.
offense.
Mm-hmm.
Lawyers, we would always say no, we didn't do that. No,
Mm-hmm.
but it's up to the Supreme Court looking at the totality of the
Mm-hmm.
circumstances, whether there are mitigating circumstances or aggravating circumstances to determine what kind of penalty must be exacted on the lawyer. Some mitigating offenses could be if, for example, the lawyer actually has no other cases before the court. This may
Mm-hmm.
be just a one-off thing that out of negligence, for example, there was no intent to cause whatever infraction there is, so the court might want to mitigate the penalty. You're not off the hook, but the penalty can be lowered. But it can
Mhm.
also be aggravated, especially if you are a repeat offender. And again, it's not about just exacting penalty here.
Mhm.
These penalties are being given in the hopes that that person would improve his or her good moral character of being a lawyer. No? So that allows that person properly reflect and to improve. Once you have been disbarred, we still believe that nothing is forever. No,
Mhm.
but there is no time period that is given by the Supreme Court when you could actually ask to be readmitted. When I say nothing is forever, of course, if you don't do anything about it, you are forever disbarred.
Mhm.
But if and when Mr. Gadon would actually want to be readmitted as a lawyer, the burden is on him to actually show that he has changed his ways. And
Mhm.
it's not a mere allegation saying that I've actually changed my ways. He has to carefully document and demonstrate that. And that may
Mhm.
take a number of years, maybe
Mhm.
even more than a decade at times, because you have to show here proof that you've actually improved and you are
Mhm.
worthy to become a lawyer. But that in itself is not a guarantee that the Supreme Court would readmit a person. No, so we have Supreme Court cases where the Supreme Court has not allowed or not lifted the disbarment.
Mhm.
There are cases where the Supreme Court actually changed its heart, no, and allowed a person to be readmitted to the practice of law.
And maybe just to close our discussion, Attorney RP, what can lawyers keep in mind, or what should all lawyers keep in mind in the exercise of profession to avoid ending up like Mr. Gadon? You get disbarred for your offenses.
Yes, maybe as ending, no, I have only four things to remind
Mm-hmm.
fellow lawyers like us, Attorney Mike.
Mm-hmm.
First is, let us remember that the practice of law is a privilege, it's not a right. So we have to always comply with the code of professional responsibility and accountability. No?
Mm-hmm.
Because we have duties and responsibilities to different constituencies, not only the court, but also to our clients, to the public, and to fellow lawyers. Second, we must remember that we are lawyers 24/7. No, we cannot say that these certain acts are of private nature or character. So we're always lawyers. We will always be judged based on our actions, and that will reflect on our fitness to
Mm-hmm.
continue our legal profession. Third is there would always be consequences if we have ethical violations. So penalties range from um, us being censured up to being disbarred if it's really grave. And lastly, since this is a reality now, we have social media. So, social media is a public forum. We have to remember that even if we feel that our actions might actually be contained in a certain space or environment, if that is actually documented and posted on social media, no,
Mm-hmm.
we cannot say, but that does not have to be in social media. No, we need to be aware that our conduct as lawyers has like a CCTV that can actually be
Mm-hmm.
uploaded. No? So we have to be careful with our actions because again, it's not just merely a reflection of our character as a person, it also reflects the profession, the legal profession, and the dispensation of justice in general.
Right. So great things to remember in the exercise of profession. Thank you so much for sharing, Attorney RP Santiago.
Thank you very much to Attorney Mike. Hello again to everyone.
Right. And if you wish to read the full text of the per curiam decision of the Supreme Court on Banc, just search for AC number 13521 in Re Attorney Lorenzo G. Gadon's viral video against Raissa Robles. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
This week at the Supreme Court.
After 7 years, the Session Hall of the Supreme Court of the Philippines, Baguio City, opens its doors once again. This time for the continuation of the oral arguments for the PhilHealth cases.
Held on April 2 and 3, 2025, the court resumed and concluded the oral arguments on the petitions regarding the transfer of the 89.9 billion peso excess funds of the PhilHealth to the National Treasury. 3 petitions challenged the return of excess reserve funds from government-owned and controlled corporations to the National Treasury to fund unprogrammed appropriations. Matters discussed included the Universal Healthcare Act, particularly the sections on premium contributions and program reserve funds, as well as current contributions of members and case rates. Among those called for interpellation from the side of the respondents were Solicitor General Menardo Guevara, Secretary of Finance Ralph Recto, Government Corporate Counsel Solomon Hermosura, PhilHealth President Dr. Edwin M. Mercado, and PhilHealth Senior Vice President Renato Limshaco Jr. Counsels for petitioners Attorney Nery Colmenares, Attorney Paula May Tangkeying, Attorney Christopher John Lau, Attorney Maria Cristina Piambot, Attorney Jose Sonny G. Matula, and Attorney Catherine Jessica Destor Ginigundo also answered questions from the justices. The amici curiae included former Department of Finance Secretary Margarito Teves, health economics expert Dr. Orville Jose Solon, Ibon Foundation Executive Director Sunny Africa, and Public Budget Analyst Ziza Nadine Suzara. The court required the parties, including the amici curiae, to submit their respective memoranda within 30 days. The Supreme Court has ruled that companies issuing registered securities must use only certified public accountants or CPAs accredited by the Securities and Exchange Commission or SEC for independent audits of their annual financial statements. The court en banc through Associate Justice Ricardo R. Osorio declared valid Rule 68, Paragraph 3 of the Implementing Rules and Regulations of Republic Act No. 8799, otherwise known as the Securities Regulation Code, and SEC Memorandum Circular No. 13, Series of 2009. These rules require CPAs serving as external auditors for corporations issuing registered securities to obtain SEC accreditation. The SEC held that the Accountancy Act does not limit regulation of the practice of accountancy to the Professional Regulatory Board of Accountancy. The Securities Regulation Code and the Revised Corporation Code give the SEC powers to implement the state policy to protect investors, ensure full and fair disclosure of securities, and minimize insider trading, which harms the free market. The court said the accreditation requirement is not a regulation of the accountancy profession, but the specific activity of auditing. Thus, CPAs engaged merely for bookkeeping or other non-audit services are not required to be accredited by the SEC. The Supreme Court has clarified that the time limit or prescriptive period for prosecuting crimes, including those under the 2022 Rules on Expedited Procedures, stops running once a complaint is filed with the Department of Justice, not when the case reaches the court. In a decision written by Associate Justice Henry John Paul B. Inting, the SC en banc abandoned its rulings in the 2023 cases of Republic v. Desierto and Corpus Jr. v. People, which previously held that the prescriptive period for crimes covered by the 1991 Revised Rules on Summary Procedure stops only when the information is filed in court. The SC also clarified that under Section 281 of the 1997 National Internal Revenue Code, the prescriptive period for criminal tax offenses that are not immediately known starts from the time the violation is discovered. The prescriptive period is interrupted once a preliminary investigation begins. The Supreme Court's Committee on First and Second Level Courts Performance Evaluation held the second leg of the Performance Development Framework or PDF for the High Performance Courts in San Juan La Union on Friday. Led by the Office of Committee Chair Associate Justice Alfredo Benjamin S. Caguiwa, the project aims to ensure the creation of an environment of excellence in court performance both qualitatively and quantitatively. Deputy Court Administrator Leo T. Madrazo led the discussion on the salient features of the PDF, which will enable courts to track and evaluate their individual performance and make use of tools and trainings in order to make improvements. The Office of the 2025 Sharia Bar Chairperson, Associate Justice Antonio Tico Jr., has issued a notice to the 2025 Sharia Special Bar Examinations, or SSBE, applicants on the local testing centers and venue assignment for the 2025 SSBE. The 4 venues for the 2025 SSBE are University of the Philippines, Diliman and Quezon City, Mindanao State University Iligan Institute of Technology, Ateneo de Davao University, and Ateneo de Zamboanga University. Starting April 7, 2025, the 2025 SSBE examinees may access their assigned testing venue through their respective barista accounts. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Lawrence Olanio as sound editor, and Tyke Flores and Jerome Batumalaki as web editors.